Hello everyone, I'm Ron Jankowski bringing you Wills, Trusts and More, and of course I have our favorite guest, Eileen, Kerlin, and Walsh. Welcome back from a nice vacation period.
Yes, indeed. Thank you, Ron. I did get to visit Ireland, I got to visit Rome, had a wonderful time, recharged my batteries, and now I'm better than ever.
Oh my gosh, you're just bubbling with power and raring to go. Very good. You've put together a little bit of a topic for us today, and referring to discrepancies and updating things that are necessary on your estate. After you've created one, a few years have gone by, the family has grown, additions to the family, lots of things may have changed, and you need to take that into consideration. Eileen, I'm going to let you take it from there.
Lovely. Thank you, Ron. Yes, we congratulate everyone who has got their estate plan done. That's terrific. You're in the top 40%. Many people do not. But once you get that plan in place, there may be times it does need to be updated, reviewed. Laws change. Our tax laws changed tremendously in the last few years. So if you have a plan from the 90s or the early 2000s, it may very well not reflect the most recent Illinois or federal tax law. The power of attorney for healthcare changed fairly dramatically January of this year. Now, if you have an old plan, it isn't necessarily out of date or ineffective, I should say, just because the law has changed. But these institutions get used to looking at a new document, and the older yours gets, the less chance there is that it's going to be quickly and easily used when the time comes. So great that we have an estate plan in place, but let's take a look at it. If it's been more than 2 years, it's time maybe for a tweak, a review, make sure that everything in there is still as you would want it to be.
Well, sometimes you may have changed your mind as to whoever is going to represent the estate. And what's the proper terminology for that person?
Lots of terminology. I wish there was just one, Ron. But absolutely, that's one of the main things. Who are your agents under power of attorney? Are they still competent? Are they still willing?
That was my point. Are they still competent? You may have changed your mind about that, the behavior and et cetera.
Exactly. You may have had a chance to observe them. How are they handling their own finances? Have they gone through a divorce? Have they married someone that you might not have trusted the way you did their previous spouse, or when they were single, or they don't have the same amount of time as when they were single? Who have you named as the guardians for your children in their documents? Is that someone that you still think would be a good choice? Maybe some people have passed on. We often find out when we review documents that the original agents have passed on, or maybe now your children are fully grown and you had your family named and now you need to name them. So agents under power of attorney, executors of a will, trustees of a trust, these are all agencies that we need to review to see if we still have the proper people in place.
Well, you have one thing mentioned on here, and I thought that was very interesting. You may have inadvertently named a minor as a beneficiary.
Yes.
Maybe thinking eventually that minor will become an adult, and maybe that has all changed.
That's exactly what happens. For often parents or a couple, when they get married, they name each other because that's all they're thinking about. No children yet. Then they have the children and they think, we need to get the children on our retirement plan, on our insurance policies. But just naming these little guys is simply not enough, because if they're under the age of 18, when they would be getting this money, then a judge is going to have to appoint a guardian for them because they are not yet able to take care of their own money, their own affairs. So you want to nominate whom you would want taking care of them. We've certainly talked about that. But who would you want taking care of their money? And how are they going to get that? We sometimes have young parents who have very large life policies, insurance policies. So if you just named a child, maybe you'd want to name a children's trust. Maybe you want to update your will to include a testamentary trust, or even go to a revocable trust. Have children's trusts in there. Focus on their education. Make sure that whomever is taking care of their money for them knows what you would want and is actually legally obligated to do what you would want. So just naming the children is not enough. We need to do more. So today we're really educating those very responsible people who have taken some steps, how to take maybe a couple of extra steps to maximize the responsible decisions that they've gotten into their plans.
The other thing that you just touched on is if you don't have that in mind about if you're going to leave an inheritance for a family member, let's say it's a child or it's a young adult, and you want that stretched out a little bit, you want that over a period of time, there are instruments out there that you should be considering or you should be really looking into to take care of that distribution.
Yes.
And maybe the distribution is over many years.
That's exactly right. Again, maybe a couple have known that a trust is going to avoid probate and they get a trust in place and they give their child an outright distribution. Well, maybe we could do a little bit better with that trust. Perhaps we could create a general needs trust for their children, maybe in their 20s or 30s, or for some reason we want to graduate the distribution, not get all of it at once.
Exactly.
And protect that money from divorcing spouses and creditors. That's an important part of how we could really maybe make this a lot better. You also touch upon retirement accounts. This is tremendous. Often really responsible parents, when they're doing their estate planning, they'll look at IRAs. They'll know that if they name the children individually, their adult children, they can stretch that IRA, create family wealth, make that last for much longer and put off paying the tax. So often the parent had to decide between, well, if I name them, they could just cash it out immediately, but they could also stretch it, versus a trust which would give them that distribution over time, but it would have to be cashed out. We'd have to pay the tax. Now, especially since the Supreme Court recently determined that inherited IRAs are not protected from creditors in bankruptcy, we have an extra option. It's a sophisticated tool, but we're now talking to those who really have great tools in place and how to make them better. You now can have the best of both worlds with an IRA trust. You can still name the individual in order to comply with the IRS requirements, but then you can also have that then flow to a cumulative trust. We really do have terrific tools that might add to what you have already in place and make it better.
Well, will any of those instruments help protect the inheritance from someone contesting?
Well, that's something that very simply can be gotten into an estate plan, and I do often find when I'm looking at older plans that it is missing. Our clients want to make sure that what they have legally in place stays in place. Sometimes there's reason for an unequal distribution or even a disinheritance, or someone's money is being protected for their own good. Well, is that going to be contested? We can put simple language in there, a no contest provision, or what we call fancily an in terrorem provision, which means that if someone doesn't like what they're getting and then they contest that, then they're going to take nothing at all. It's a very powerful and a very simple tool that's going to make sure that that person's going to think once and twice before they decide that they're going to contest what they got, because they don't like what you did. And often parents do this to protect a child who may be vulnerable, who may have maybe a substance abuse issue. We really want to make sure that the protections the parents put in place are kept in there. And these interim provisions are a wonderful way to do that.
Okay, I have a question about beneficiaries.
Okay.
Insurance beneficiaries versus a trust. Which one overrides the other if they don't say the same names?
That is a brilliant question. And so often our clients think the document they have in front of them, if it's a simple will, what they say in that will is now just going to somehow magically translate to all their assets. Well, it will if there are no beneficiaries named. Beneficiary designations are extremely powerful. They trump what's in a will or even a trust. So what we have to do when we're doing this kind of review that I'm recommending is take a look at the beneficiary designations. Call your institutions, ask them for a copy of what you have currently and a copy of a form to update it. Make sure that there's no unintended consequences. Make sure that there's no we have seen divorced spouses in there because someone never got around to
Yes,
making
cha-
sure
the
that it was
change.
updated. Remember I said very powerful. Those are things that are impossible almost to change after the fact. So take a look at your beneficiary designations. Do they match up with your estate plan? Do we have, instead of a trust named, maybe the estate of, if there's a retirement plan or an insurance policy where the estate of Eileen, Kerlin, Walsh is named, that's going to the probate court, going to the whims of the court. We've got to make sure those beneficiary designations match our intentions and match up with the estate plan we've put in place. Great question. Something that often leads to horribly unintended consequences.
Yes, I've heard of that, and I didn't really know what outweighs the other, and you just shared that. And because there are so many variables to this, I'm going to suggest for the viewers that are maybe getting a little confused with all of these things that you have to be concerned about, that you do talk to your professional person that you have, or call Eileen, and we're going to put her number up and give her a call, and maybe she can answer your question and unconfuse you, or meet with her.
Yes.
The other thing, and you have already touched on this, is making sure that your executors and your agents that you all put in place are still every 2 years or whatever that period is, is changed or to remain the same. You're pleased with that. That's very,
Absolutely.
very important.
Take a look at it, make sure it's the right people. Another thing that I want to mention today, Ron, is incapacity. We often talk about how planning for our own incapacity can get neglected. We often plan for after death. But that incapacity, let's take a look at that. When you did your will and trust, did you have powers of attorney? If you don't, let's get them placed. If you have powers of attorney, let's look and see who those agents are. And most importantly, what power have you given them? Here's something we've seen happen. You can allow the agent to make all the financial decisions that you would make for yourself. But what if you, from an individual account, take care of a spouse or take care of a sick sister or make gifts to your children? Your agent, unless you specifically give them authority to, aren't able to do that. So take a look at those documents. Are they sophisticated enough and up to date enough to match exactly what you do in your lifetime while you're competent, that they can do that for you? So this is another little area where we, even with the document in place, and even with the right person, we may not have given them enough authority to match your life. These documents are often statutory. They say exactly what the statute says, but we sophisticated estate planning attorneys know that we can expand out that authority that the statute gives it, or we can minimize it. So are each of your documents specifically tailored for your life and your circumstances? We can do that. So in conclusion, what I'd want to say, Ron, is congratulations for getting any documents in place, for having a plan in place. Now, since you've been responsible, let's just take a look at it. Look at what you have. See, does it need a tweak? Does it need a review? We may just say, wonderful, everything's exactly the way you need it. The law hasn't changed significantly to affect your plan, and we'll not look at this again for another 2 or 3 years. But every single time we take a look at a plan, I have a client say, I had no idea that was in there, or I had no idea that I didn't have this taken care of. So take it out, make sure you know where it is, and then we can talk again about maybe getting it updated for digital assets. If this is something you did 10 or 15 years ago, at that time you may not have these online accounts, you may not have a list of passwords, you may not have some of the online digital assets that you have now. So it's such a good idea and money well spent to take a look, make sure it reflects your intentions now. If there's any deficiencies, let's get them dealt with, and then you can put it away and retain that peace of mind that it gave it to you in the first place, because you're completely up to date.
Does, if you were to have a client come in and have you do a trust, power of attorney, etc., would you have a copy of that if the family could not find the master copy at home? Is there a way that maybe just the attorney's name and then the attorney shares this with the family?
This is another great question, and it happens sometimes that when a client goes to review their plan, they realize they can't find it. So if they know who originally drafted it, now the original drafting attorney, if it's been a very long time, maybe 20, 30 years, may have kept the original. That would have been the procedure then. It's very unlikely if it's in recent years that the attorney would have kept the original. People are much more mobile. Often their own trustees and executors don't necessarily need that facility. So first, if the documents are lost, we would want to go back and find who drafted them. Might they still have a copy? And if the attorney who drafted them still has a copy, then they can certify something that would really need to be kept original, such as a trust. They can recertify a trust or even restate a trust. Powers of attorney would never, if they're that old, are most likely need to be updated anyhow, and they're not something we can recertify or even update or codicil. It's usually a new document. But that's actually another good reason to get out your plan and review it, because you might find that you don't know where it is. You might find the box is gone, there was a move, you thought it was in the safe deposit box, but it isn't. So sometimes reviewing the plan makes you realize that you don't know where that plan is. Now, there's always something can be done. We have found that all the documents are lost and there is a trust, and that trust is funded. Now, there are assets in the name of that trust, we need that original document. Well, we can restate that document. So there's always a way to be able to handle these situations, but far better to know that you're dealing with lost documents before the documents are needed. And then we can get everything in place that we need to reflect the old plan and update it with anything that either hadn't been done or is now out of date.
Eileen, another excellent topic that you covered. You usually do bring some very interesting things. Hopefully this is part of an educational process for the viewers that are not doing their work, their homework, and their planning that they should be doing. So again, I'm going to put Eileen's number at the bottom of the screen. If you do not have a professional person, an attorney, etc., to help you with this, that you may want to give her a call and talk to her and go from there.
Always delighted to help. Thank you, and thank you, Ron.
Thank you, Eileen, for coming back out, and we'll see the viewers in about a month again with another interesting topic.
Great.
Very
I'll
good.
be here. Thank
Good.
you.
Bye-bye.